Do you believe in what you see on the surface? Do you always trust authorities? Are you convinced that no one is above the law in a democratic society? Would you believe in the existence of a corruption scheme involving over 100 people, including 7 judges, that is being covered up by government, regulators, police, judiciary, and even the media? A while ago, I was just like you, and would have ruled out such wild conspiracy theory. Let me tell you the story, which reveals what is hidden from most people. After reporting and attempting to collect evidence of fraud in a large corporation, I was cut off the network and dismissed from employment. The company took me to court and corrupted judges who ordered me to destroy all evidence, threatening with imprisonment if I don't comply. To further intimidate the only crime witness who couldn't afford a lawyer, I was ordered to pay over £100,000 in legal fees without explanation. Sounds like exaggerated fiction, doesn't it? There are so many hard-to-believe details that I will only cover the main ones in this story. My name is Artyom Borisov. I was employed by Zurich Insurance in London in 2013 as a software developer. Zurich is Swiss' largest insurance company, employing 54,000 people globally, with $400 billion in assets and $5.3 billion of profit earned in 2019. I joined as Microsoft Excel specialist and took over an application called PlumZ. For over 5 years, the tool has grown substantially, serving over 1,000 users and processing billions of dollars in premium for the company. My effort wasn't recognized by management above me because I produced quality functionality at a fraction of the cost, which was a threat to major IT projects with large budgets. Yet people were always polite and there was no conflict. I enjoyed my job. I liked to keep users pleased and was happy to serve Zurich without asking much in return. In October 2018, Global Head of Property Susan Fallon came up with a new approved IT project called Underwriting 360. Nobody ever discussed the plans with me, and when I first saw project presentation, it simply didn't make sense. As an in-depth specialist in the area, I later realized unthinkable. Every word in the presentation was either an intentional nonsense or a lie, something that was not immediately clear to most other people. Underwriting 360 looked very nice on the surface, but in reality, the project could not add value to the company. Apart from wasting millions, the plan was also to decommission PlumZ, and that, in fact, was technically impossible without negative consequences, something I tried to explain in this document. The only new functionality that was not already available in PlumZ, which Underwriting 360 promised to build, was auto-scrubbing of raw data. I offered my line manager to develop such functionality in PlumZ much faster and free of charge, but he declined my proposal. We stopped having usual conversations together, and instead I started to experience psychological manipulation. I decided to build the missing functionality on my own in PlumZ, and when finished with the task, I prepared a video demo of it. At some point, I recalled Zurich internal rules, stating that employees had an obligation to report wrongdoing. On 1st of December 2018, I sent an email to the head of IT reporting Underwriting 360 project to be a fraud and explaining the reasons in consequent email chain. Tony suggested I should meet with my line manager and a wider team. When we did, Underwriting 360 team couldn't properly answer my questions and could not explain why we cannot release or even show new auto-scrubbing functionality to users. I continued to insist about fraud, and a few weeks later I was contacted by Graham, Angela, and Mark from Compliance Department. New investigation team acknowledged that they are not specialists to look into economic or technical merit of Underwriting 360 project, and for this reason I selected the most simple and obvious items to be investigated. 1. Why we cannot release or even show PlumZ auto-scrubbing functionality. 2. Why Underwriting 360 project makes false statement that decommissioning PlumZ and Compass will bring 1 million savings a year, when there is no evidence of any savings whatsoever. 41 days later, Compliance Department concluded that no fraud was found. At first, I thought it was simply gross incompetence. Later, I realized it was a well-considered cover-up. First of all, investigation team diverted my allegation of fraudulent project into personal misbehavior. Secondly, the team discussed my accusation only with Susan's line manager and no one else. When referring to my specific questions, Graham simply ignored answering why I was forbidden to release or even show functionality that potentially saves millions today. Similarly with cost savings, report makes a blunt statement that it's a correct figure without providing any explanation or evidence. I wonder if investigation team would have believed in $1 billion per day savings in same manner. Graham writes some more nonsense, concludes that no fraud was found, and signs the report. In the email sent together with my investigation results, I am being warned by Graham, and later the same day, directly threatened by my line manager to not talk to anyone, since it is not part of my role or mandate. I decided to write an email to CEO of Commercial Insurance, James Shear, who holds one of the most senior positions in the company and who ultimately approved the funding of Underwriting 360 project. Jim Shear responded that he is satisfied with the outcome of the investigation and with the merits of the project, and asked my line manager to meet with me to consider alternative options if I remain embedded in my current view. Several days later, my line manager stated that my employment is at risk of redundancy. At the end of the letter, Claude reminded me that I should not attempt to retain any Zurich data, which they will monitor. I sent an email to head of IT, explaining how much I did for Zurich and asking for confirmation. Tony never responded to my email. By the time I was informed about the risk of redundancy, I finished another important functionality in PlumZ. Both new features complement each other, and for that reason, I wanted to show them together. I came up with a list of most frequent users and sent them individual emails with a demo of 2 new functionalities. 30 people responded to me with exceptionally good comments. From comments, it was clear that users did not expect PlumZ to be decommissioned anytime soon, and asked for new functionalities to be released ASAP. Few people managed to test functionality and confirm it is working. Apparently, operational and financial savings and underwriter's opinion did not matter to Zurich management. Not only functionalities were not released, but PlumZ, as business-critical application, processing thousands of clients' accounts and billions in premium per year, was left without any support after I was suspended and cut off the network the following week. Responses represented only a fraction of PlumZ user base, and such positive feedback about new functionality, which I was not allowed to show, was a new, stronger evidence of fraud. I started asking core underwriters who were behind Underwriting 360 according to project presentation. As I was expecting, they did not know much about the project and did not really support it, and did not participate in weekly project calls, in contrast to what presentation stated. I also received detailed comments from Jafar about the project. I sent an email with new evidence to the same compliance team, asking them to reopen investigation, as well as emails to the head of international programs and head of HR. I did not get response. However, there was extensive internal communication in the back, as shown in one of the emails unintentionally disclosed by Zurich. Company management realized the full gravity of the problem and decided to act quickly before I managed to collect any more evidence of fraud. On 5th of March 2019, when I was about to send another piece of evidence, I received a phone call from Senior HR Manager Carmen Coombs, informing me that I will be suspended because potentially I did not follow reasonable management instructions not to contact underwriters about Underwriting 360 project. I could not believe what I heard, and I thought that Carmen was joking. She further said that I will be cut off all IT systems, and if I attempt to contact underwriters, I could be dismissed from the company. I knew at that time that what happened was way beyond inappropriate. Much later, I realized that such suspension was not only a major breach of employment law, but also fell into 4 serious criminal charges: witness intimidation, attempt to conceal evidence, conspiracy to defraud, obstruction of justice. 10 minutes after suspension call, and 20 minutes before I was cut off, I managed to find and send an email to CEO as well as all compliance and EMEA and UK branch. Immediately after, Steve Collison, head of HR, internally replied, recommending not to respond to me and stating that multidisciplinary group will be meeting 2.5 hours after my email to discuss the issue. The group included legal, HR, fraud prevention representatives, as well as external lawyers. The email also discloses that top management was already fully aware of what was going on. The same day after suspension, I sent emails to CEO, chairman of the board, and general counsel, asking for their help. The next day I received an email from lawyer Sebastian, which I couldn't believe in. CEO and chairman of the board, instead of contacting me and saying thank you for what I did for Zurich and sorry for how the company mistreated me, forwarded all info to their lawyer, who stated that there is no fraud, Underwriting 360 investigation should not be reopened, and my suspension is appropriate. During suspension, I contacted and explained the story to my friend, lawyer Andrew, whom I knew for several years as children's warden at church. Andrew told me not to do anything while he went to a ski trip to Switzerland. 10 days later, when we met to discuss the matter, Andrew questioned the evidence that I had. He said that fraud is clearly a wrong choice of words, and Underwriting 360 may simply be an inefficient investment, which is common. Andrew in general behaved as if I'd reported something very minor. He said there is no way I can do anything to Zurich from legal perspective, and in any case, management will not lose their jobs. I thought at the time how such statement compares with Zurich laying off thousands of employees in the past without problems as part of a cost-cutting exercise. Having met Andrew several times later, I continued to insist about injustice and fraud. Andrew told me that I was simply shafted and behaved like a church choir boy who first stepped into real life. It was especially odd to hear such comments from Andrew, who plays church organ and teaches children in Sunday school. He changed conversation towards my qualifications and the kind of new job I could get elsewhere. After having very carefully thought, I came to unthinkable conclusion. Andrew started to secretly act in the interests of Zurich after the trip to Switzerland. He never supported me in any way, but didn't say that risk of redundancy and suspension were an unprecedented breach of employment law and a criminal offence, enough to open a major lawsuit against Swiss' largest insurance company. Instead, he suggested me to be a good boy, which will make it easier to get a good reference from Zurich. As I have realized later, Andrew was only one of many other false friends and advisors corrupted by Zurich. While I was in suspension, Cindy Warden, the head of Zurich Corporate Risk, was appointed to conduct an investigation into my misbehavior. During our first meeting with Cindy, I asked an obvious question: why no one is investigating a multi-million-pound fraud I have reported, but instead suspending and investigating the only witness. Cindy couldn't answer the question and stated that she was simply appointed to do this specific task. During our second meeting, Cindy revealed that my mailbox was opened up and scrutinized by IT. She tried to manipulate me psychologically, for example asking whether I thought it would be okay if all employees disobeyed management and ignored official procedures. It was also clear to me at the time that Cindy spent most of the time asking specifically prepared questions, trying to find something to accuse me of. On 4th of April, Group Head of HR wrote an internal email stating that tomorrow I will be informed about disciplinary investigation result. Michelle informs recipients that there is a triage in place to deal with correspondence from me, and she thinks that I may not react well to the news. In line with the plan, Cindy finished her investigation and concluded there is disciplinary case to answer. The end of the message contains the same threat not to contact underwriters or any other colleague or risk dismissal from the company. Cindy Warden produced a disciplinary investigation report where I am being accused of failing to follow reasonable management instructions and taking steps to actively undermine or damage Underwriting 360 project, with 2 additional areas of concern. On the surface, the document looks legitimate and well written, but upon closer look, it reveals how a large corporation fabricates allegations and falsifies evidence. Together with the report, I was sent a large volume of other documents, around 30 files. Intentionally overloading me with information which is often irrelevant and contradictory became a common practice by Zurich as a way of intimidating me. The head of corporate risk, Cindy Warden, knew very well that outsiders will not read her complex report, and even if they do, they will not see the truth behind it. On 8th of April 2019, I received an invite to a disciplinary hearing from Sean Hicks. The letter stated that possible outcome of this hearing is the termination of your employment. I wondered at the time if Zurich HR invites all employees to disciplinary hearings by intimidating them up front in such a way. The document also states that I have a right to call witnesses by informing Alison and Sean at least 24 hours before the hearing. I decided to use the opportunity, and 3 days before scheduled hearing, I provided a list of witnesses I would like to invite. Zurich management was not prepared for such request, and after a long email chain, the hearing is postponed. During the delay, I sent 9 emails to all members of Executive Committee, individually asking for help. No one ever responded. I contacted Investor Relations Department, requesting contact details of the Board of Directors. No one responded. When I tried calling, people simply hang up the phone as soon as they heard my voice. The next day, head of HR sent me an email inviting me to a disciplinary hearing in the shortest time legally allowed, 5 days. The witnesses are denied, and if I refuse to attend without them, the hearing will proceed in my absence. I suspected that Zurich decided to make me redundant ASAP, and sent another email to 9 members of Executive Committee asking for urgent help, as well as to the head of UK and head of EMEA asking them to lift my suspension. Head of HR internally responds and reassures everyone that they are extremely confident, following very robust approach and taking each step with both internal and external legal advice. Any detailed questions, Steve suggests to be better handled by phone, for obvious reasons. I sent several emails to Steve Rickards, appointed disciplinary manager, but no response followed. He received all my emails and was unsure if or how to reply. Disciplinary hearing took place on via telephone call. Steve Rickards and Alison Charnock didn't say much and only followed the script that was prepared up front. When I later saw the hearing notes, I could not believe what I read. Not a single word in the document reflected what was said during the hearing. I was portrayed as a person with mental problems who could not express himself properly. On 25th of April, I received a letter from disciplinary manager informing me of my immediate dismissal. I did not expect such outcome, because I always had doubts that Zurich will actually make me redundant, definitely not in such a manner. Dismissing an innocent employee who reported major fraud against shareholders and added so much value to the company without a reason, without notice, and without pay was simply beyond comprehension. I asked head of HR to explain instant termination of employment, which only applies for very serious misconduct, such as violence, fraud, and drugs. HR replied with more nonsense, requesting me to return all devices and destroy all documents I possess. After 5.5 years of service, I was instantly dismissed and paid only for unused holidays. I sent yet another email to every member of Executive Committee, but never received any response and was coming to conclusion that all of the Zurich top management, including CEO, Executive Committee, Chairman, Board of Directors, whole legal department, and HR, joined against me in covering up fraud. This conclusion is backed up with the evidence of 2 additional emails. An earlier one where Group General Counsel debriefed a member of the Board of Directors about my case, and second email where a member of Executive Committee and head of EMEA, Amanda Blanc, expected my plead for help but never responded. After dismissal, I sent 400 individual emails to property underwriters, but no one replied, and it felt like the whole world turned against me. The reality was that people did not receive my emails because they were blocked by Zurich IT. Head of HR later confirmed they were blocking my communication with an email quarantine. Knowing that Zurich is blocking messages from my original address, I opened a few dozen new email accounts and sent individual emails to thousands of employees using mail merge. Some of the emails I sent were hidden inside other innocent-looking messages, and some were dynamically coded to avoid keyword filters. One Zurich colleague I secretly managed to contact told me that my email magically disappeared from his Outlook without trace, even from sent items, as he forwarded it to others. While I knew that most companies have sophisticated email protection features, it came as a surprise to me that Zurich can actually act as a big brother. At the end, Zurich IT managed to trace all my hidden messages out of the stream of millions of emails and confirmed that 7,628 people received them. Head of HR called me once, asking me how I feel and what I wish to achieve by sending mass emails. Steve had a script prepared for the call, which he followed. The script shows that Zurich was more interested to assess his state of mind rather than explaining reasons of my dismissal. Zurich management knew that many employees read my emails with such shocking allegations and had to respond to it. Continuing the same strategy, management decided publicly to make me the bad guy and sent this communication to every employee who received my emails. Official Zurich instructions had an expected effect. I tried calling colleagues I knew well, but after several failed attempts, I realized that people were simply avoiding me. Underwriters who had responded with such positive comments have now turned away because Zurich officially told them that it's me who is the offender, dismissed for misbehavior. Zurich management trampled over everything I cared for. I devoted 5.5 years of my life building a major IT system without asking for much, because my true reward were the users, pleased with new functionalities and the value I could add to the company I promised to serve. Zurich management did not share my values and did everything to ensure that everyone abandoned me without saying a single kind word. After dismissal, I received a letter from Zurich lawyers instructing me to urgently return laptop and iPhone. For disobedience, I was threatened with legal action and potential liability to pay legal costs. Zurich management and DAC Beechcroft knew well that I did not have money, couldn't afford a lawyer apart from Andrew, did not have any legal knowledge or experience, and couldn't assess whether the threat is credible. I refused to return devices because it contained fraud evidence needed for police, financial regulators, and courts. A week later, I received a second letter from DAC Beechcroft, giving me final opportunity to return all property and further threatening me with significant legal costs. On 23rd of May, I was delivered a large pack of documents, which I understood to be a claim opened against me in High Court. The pack included application notice, claim form, head of HR witness statement, draft order. Zurich wanted me to destroy all company information and evidence I possessed and return all electronic devices. Mr. Collinson's witness statement was intentionally very long, complex, and repetitive, with all the facts distorted to show the opposite of truth. I was portrayed as an aggressive, cynical offender, dismissed for misbehavior and acting for personal financial gain. Head of HR did not explain why he thought so. After spending a lot of time thoroughly studying all documents, I understood that I need to complete defense and counterclaim form and send it to court, which is what I did. I had to do everything on my own because I simply couldn't afford a lawyer. Zurich knew it well and sent me thousands of pages of intentionally complex documents and hundreds of emails with conflicting instructions. Dismissing an innocent whistleblower who stood up for the truth and then taking him to court was an act of unthinkable arrogance. I couldn't believe it, and thought that Zurich simply tries to intimidate me without suspecting their sinister plan. First time in my life I came to court hearing was 5th of June. I was met by around 10 people, and they were very polite, quite the opposite of what they wrote in the documents. Since I did not have a lawyer, a free legal advice was offered to me by Jonathan Nash. He suggested me to give all devices and all info I possessed to Zurich lawyers for safekeeping. I had no legal knowledge, but expected quite the opposite support. That is how to defend myself against nonsense claim, or how to take criminals to court for what they did. I suspected Zurich to corrupt more people. I did not trust Jonathan, and declined to be represented by him. At the hearing, I was surprised to see High Court Judge Arnold displeased with me, because I allegedly did not follow formalities correctly. He asked me why I did not wish to return property to Zurich, if, as I stated, I already got a copy of all documents. I did not wish to waste time arguing, and agreed to return devices as well as to provide some information, and promised to temporarily maintain confidentiality of documents. It is clear to me now that I was simply tricked. Considering the size of penalties large corporations face for misconduct, the judge should have issued a multi-billion-dollar fine to Zurich. Instead, Judge Arnold issued an order against me, which has a warning of imprisonment and confiscation of assets if I disobey. I did agree to all terms of the order myself, but I was deceived by the judge, Zurich, and corrupted advisors, who took advantage of my lack of legal knowledge and experience. Zurich lawyers in the meantime kept sending emails urging me to seek legal advice to avoid legal costs. 3 weeks later, I came to the second hearing before Judge Michael Green. I stated clearly that I wished to keep all confidential documents. The judge agreed that I can keep the information, but suggested that it is reasonable for Zurich to ask me to limit its use and public disclosure. He said that my allegations of fraud against Zurich were separate, and I would have to be investigated at a different venue, such as employment tribunal. While the judgment looked adequate on the surface, in reality it was yet another deceit. Instead of penalizing the offender, the judge again issued an order against me, where I was instructed to provide information and restricted to use confidential documents. When I thought that all legal proceedings were finally over, I was taken to court again. This time, Zurich accused me of not serving a defense, meaning I have not responded to their original claim. As usual, Zurich tried to confuse me with irrelevant statements, none of which I understood at the time. I thought I have not followed some minor formalities and Zurich simply terrorizes me. The court scheduled the hearing at an unprecedented 7 days' notice, without even asking whether the day is acceptable for me, which they should do by law. It was illegal, and I could not attend on 16th of July because it was the first day in my new role after 3 months of searching since I was dismissed without pay. I wrote a response and sent my wife to court while I was at work. At the hearing, the judge and Zurich lawyer discussed in length nonsense formalities, which I allegedly did not follow. Conversation was clearly rehearsed and staged, with an intention to confuse and intimidate me. Justice Mann asked for last words, and my wife said that we are victims of major corporate fraud scheme, have 2 little children, no money, and have done absolutely nothing wrong. The Honourable Judge did not take any notice and started discussing the costs I will have to pay now. At the end, he ordered an innocent whistleblower to pay Zurich £57,000 in legal fees. For a corporation with $400 billion in assets, that was not a large amount, but for my family, it meant bankruptcy. I was ordered to irretrievably delete all evidence, then swear I have complied with it. In addition, I had to provide all private PIN codes and passwords from all devices and documents. The order didn't say anywhere what I can do if I think the judgment is unjustified. Instead, it said that I may be imprisoned and my assets seized if I disobey. To intimidate me further, Justice Mann called it the final judgment, refusing me the right to appeal. I was not at the hearing and only saw the order the next day, on 17th of July, when Zurich lawyers sent me another threatening letter. The day after, on 18th of July, I already had to provide all personal PIN codes and passwords to Zurich. I had just one day to make a decision what to do next. At the time, I didn't understand why that order was issued and what judgment in default even means. I didn't know if I am already blacklisted as a debtor and offender, since there were 3 judgments against me now. In my break time while at work, I started calling different lawyers, trying to explain what happened and asking for advice. As in my previous experience, nobody was prepared to do anything without an upfront fee. Considering the complexity and the size of Zurich, lawyers asked for a minimum of £5,000 prepayment just to briefly look into the case. They said that corruption doesn't exist in UK judicial system and thought that I am either crazy or not telling them something important. None of the lawyers were willing to give any advice, especially in one day, and the only free advice they could give is to comply with the order or risk facing a prison sentence. Zurich carefully considered and predicted such scenario, which was the essence of their sinister blitzkrieg plan to destroy me quickly. First taking the victim to court at 7-day notice, and then giving me no time even to understand what happened. During that one day, following inner voice, I made a crucial decision, not to comply with the order, despite the threats from Zurich, the judge, and against the advice of all lawyers. Later, when I learned legal formalities, I understood that refusing to comply with the order was the only right thing to do. Let's look closer at the judgment and the comments which Justice Mann produced to explain his decision. The judge writes a long, intentionally complex text with details accusing me of not preparing a defense to Zurich's claim, despite being told to do so. His comments miss out the most crucial fact. I did write a defense to the claim, which was sent to court fully in line with all instructions, and Zurich also confirmed to have received it from me. I have not failed to serve a defense to the claim. There couldn't be a judgment in default because I have not defaulted. Not only I prepared all documents correctly, but also physically came to hearings to defend myself. Zurich application for default and the judgment were nonsense. Ordinary people may say that they don't understand anything in these legal details. That is exactly the response criminals are counting on, which enables them to cover crimes from public and hide behind complexity. Looking further, Justice Mann did not explain why he ordered me to provide personal PIN codes and passwords. There is no reason for such request because Zurich IT can access devices using administrator credentials or as a new user. Most importantly, the judge did not explain why he ordered me to delete all Zurich documents I possess. In fact, according to Criminal Justice Act 1987, Section 2, Paragraph 16, an attempt to conceal or destroy potential evidence is a criminal offense. The judge ordered me to commit a crime, and at the same time, evidently broke the law himself. I wonder if this case will ever appear in law textbooks. What should a person do if the court ordered him to murder someone and then refused the right to appeal? Finally, Justice Mann doesn't explain anywhere why he ordered me to pay legal costs. In general, judges can order a losing party to pay for the lawyers of the winner. In my case, though, there was no reason whatsoever why I had to pay any legal fees to Zurich lawyers. They spent all their effort fabricating nonsense allegations against me at the time when I couldn't even afford a lawyer and had to learn and do everything on my own. I did not understand all of these things at the time and came to High Court next day for consultation. Free legal advice was given by Albert Sampson. He said that if I don't comply with the order, Zurich may put me in prison, and if I don't pay, Zurich may try to make me bankrupt. Albert argued that any attempt to review, change, or cancel the order may result in even higher legal fees that I will have to pay. When I asked why judgment in default was issued when there was no default, Albert said that the judge already considered everything, that the order was issued, it was a serious order, and that I had to comply with it. It became clear to me that Albert was yet another false advisor, secretly acting for Zurich. I found myself in a situation where all free lawyers were either corrupted, unavailable, or afraid to help me after I told them about my case. I thought that perhaps I could find a lawyer willing to support me in a no-win, no-fee basis. After contacting 1,000 lawyers from world's top 100 legal firms, I found no such help. Left with no choice, I searched online and figured out how to take Zurich to court myself. In the course of the next 3 months, I've opened several applications to cancel the order, to extend deadlines, and a counterclaim against Zurich. Documents included 30 new pages of witness statements and exhibits with 500 pages of evidence. The next hearing was scheduled at the end of October, 3 months after my first application. It's a far cry from 7-day notice period when I was taken to court last time. Corrupted High Court administration was acting for Zurich and simply put me in the furthest time slot available. Fourth hearing was before Justice Michael Green, whom I saw second time then. During the hearing, the judge simply ignored answering my numerous direct questions: why my defense was not valid, why I have to pay legal fees, why I have to destroy evidence of fraud, and why I have to provide my personal passwords. Instead, he tried to accuse of not following rules and instructions. Most of the time, the judge and Zurich lawyer discussed nonsense details and formalities. Just like in previous hearings, the conversation was clearly rehearsed up front. The intention was to intimidate me with the complexity of legal proceedings and unfamiliar language. At the end, the judge dismissed my application to cancel the order of Justice Mann and all my other applications. He pardoned Zurich for their failure to comply with the order, granted them an extension, and ordered me to pay an additional £22,000 to Zurich. In his comments, the judge warned me of imprisonment if I continued to disobey orders. I didn't give up, and in January opened a claim against Zurich lawyers, DAC Beechcroft, accusing them of intimidation, obstruction of justice, fraud, bribery, attempt to conceal and destroy evidence, fabrication of allegations, making false statements, and falsification of evidence. The hearing happened at the same High Court, and therefore the outcome did not surprise me. Master Schumann dismissed my claim as being totally without merit, ordered me to pay £30,000 to DAC Beechcroft, and refused the right to appeal. Despite rejection, I applied for a permission to appeal and explained in detail why the ruling was a major error in law as well as a violation of human rights and fundamental principles of access to justice. Master Schumann was fourth High Court judge, corrupted by Zurich. In parallel to High Court proceedings, similar flagrant lawlessness was taking place at Employment Tribunal. At the case management hearing, Judge N. Diol questioned whether I am a whistleblower at all. He was satisfied with how Zurich prepared for the hearing, used their documents, and accused me of not following formalities. I wrote and said that Zurich dismissed and continues to intimidate the only witness of fraud, requesting me to destroy all evidence which I need for Employment Tribunal. The judge said that High Court is higher than Employment Tribunal, and if they ordered me to do something, I need to comply with it. He didn't say that destroying potential evidence is a criminal offense. He told me to disclose all documents I have to Zurich and agree with them on what I need to delete. I asked for urgent legal support, which the judge refused. Instead, he issued an order requesting me to provide full details of my whistleblowing claim by 22nd of October. Without lawyers and without experience, I was given 1 week to provide full details of the worst employment tribunal case in UK history. It is clear now that Zurich intended to overload me with complex information and requirements with tight deadlines. Their plan was to accuse me of real or made-up formalities which I did not follow and strike out my claim altogether from Employment Tribunal. With the help of High Court, I was also supposed to be left with no evidence to prove anything. I did provide required information on time, yet Zurich lawyers requested final hearing to be postponed on the grounds that I am in breach of the order. Despite me explaining all the nonsense of Zurich arguments, another Employment Tribunal Judge Wade decided that I have not complied with the order. She warned me of striking out my claim if I don't provide correct information on time. For example, if I don't explain why I believe my disclosures are protected under Section 43AF of the Employment Rights Act. I wonder how many whistleblowers that come to Employment Tribunal know what all those words mean. At the end, Judge Wade indefinitely postpones the hearing, exactly what Zurich has asked for. She thinks that 2 months is insufficient time to prepare without explaining why. Judge Deol, for example, thought that 7 days would be enough for me. 1 year has passed since my original application, and 6 months since last letter, and I have not yet heard from Employment Tribunal. I wrote a letter accusing Judge N. Deol of corruption and requesting a new case management hearing, as well as another email to the President of Employment Tribunals. Judge Brian Dole, the President of Employment Tribunals, responded that he has not found any evidence of misconduct. He does not explain his decision, yet notes that judges are independent and there are limited grounds and strict time limits to appeal decisions. Remarkably, it took the President just 5 days to review such serious allegations and come to a conclusion. Also, the letter was sent exactly after High Court hearing on 30th of October, where I was ruthlessly defeated by Zurich. Is it just another coincidence out of many others? Judge Wade, the one who cancelled and postponed final hearing, is copied in. According to Public Interest Disclosure Act 1998, vulnerable whistleblowers should be protected. Employment Tribunal, however, specifically empowered to enforce the law, has also teamed up with corporate criminals and does exactly the opposite. To support me in my struggle against Zurich, the company sent me a lot of different friends and advisors, in addition to lawyer Andrew. I will not list them all due to the lack of hard evidence, and I will only mention a few of them. Rupesh Davda, an actuary working in Zurich, got in touch with me when I sent mass emails. He said he was a victim in a very similar situation, yet when I later explored, his case was quite different. After failing an exam, he sued Institute of Actuaries because Indian students have 2 additional yearly time slots to take exams via a different organisation. Employment Tribunal awarded him with £38,000 for discrimination. He told me that he is tired dealing with endless legal procedures. He has been bullied. He's scared for his job. I have very little chance with regulators. It will ruin my life my wife may not speak to me, that we are both victims, and that I may have to pay even more fees if I lose. Similar kind of support I heard from employment lawyer Chris Pavlou. After losing at the hearing on the 30th of October, I thought about the scale of reputational and economic damage which I was intending to inflict on UK and Zurich. I was not sure if revealing such dark secrets was in the best interests of employees, shareholders, and population of UK and beyond. I offered Zurich to discuss possible settlement options and asked Chris if he could help with that. Chris responded that he is away and suggested to have a chat later on. I already suspected him of secretly working for Zurich, but didn't mind. Yet I was surprised about how they decided to approach negotiations. Chris didn't pick up the phone when I called him, and later when we finally got in touch, only had 5 minutes to talk. He thought that my position is not strong enough, considering all High Court orders against me. In his tone, Chris implied that I would be lucky if Zurich agrees to discuss anything with me at all. My allegations of conspiracy he took with a slight hint of condescension and mockery. It was always obvious to me that Zurich does want to peacefully end the battle. However, they want to approach and treat me as a defeated victim who is afraid. I understood at the time that there could be no further talks with criminals. I also realized that hard truth is more important than sweet lies, and I do not wish to betray the UK people. I refused to work with Chris and filed documents to the Court of Appeal. On 4th of May, I received a rejection from the Court of Appeal. It's from the same Judge Arnold, who first heard the case in High Court and was now promoted to the Court of Appeal. Yet, with the wrong seal, no stamp, no date, and no signature. Sent by email only. The document looks like a falsification, which means I still have hope. Zurich and DAC Beechcroft, however, will not allow their victim to simply wait for justice to come. On 19th June, I received a charging order over our property, the first step to make my family bankrupt. People would say that a democratic country, such as UK and Switzerland, has everything to protect citizens and prevent injustice and corruption of such unbelievable scale. That was also my firm belief in the past. Let's explore organizations and people I have contacted about the case and their responses. We can separate them into 5 categories: regulators, judiciary, police, government, and media. During suspension on 17th of March 2019, I have reported the case to UK and Swiss financial regulators, Financial Conduct Authority, and FINMA. Despite multiple updates from me and requests to take action, FINMA has barely responded. FCA did come back to me a number of times, yet no action was taken for over a year now. So what do regulators do? FCA, for example, looks at petty theft and food theft. Public gets an impression that the disappearance of sandwiches is the worst that ever happens in corporate world. The agency will get credit for maintaining the rule of law in financial industry. The cases where millions are stolen from shareholders, where whistleblowers are dismissed and intimidated, are apparently ignored. The outlook in Switzerland is even more dramatic. In October, Zurich appointed Peter Geiger, former deputy CEO of Swiss regulator, as Zurich Group Chief Risk Officer and member of Executive Committee. With such cozy relationship between organizations, there is no sign that FINMA will ever take action against largest insurance company employing 54,000 people. In addition to financial regulators, I have reported misconduct of Zurich lawyers, DAC Beechcroft, to Solicitors Regulation Authority. I provided full details of the case with all evidence and accused the law firm of a dozen criminal charges. SRA Investigation Officer Harvinder Thandi responded. The email was sent on Saturday the 26th of October 4 days before my High Court hearing. I wonder whether it was another coincidence, or whether the timing was intentional again. After careful consideration, Ms. Thandi decided to take no action against the law firm, explaining her decision by repeating the same nonsense statements used by Zurich in the past. Just like everyone else, she refused to carry out independent investigation and tried to hide behind the decision of a judge. The natural direction of complaint about judges is within the judicial system. To find out what to do and where to go is not easy and requires a lot of research. I wrote to Upper Administrative Appeals Chamber, Magistrates Complaint Office, Property Chamber President, and Regulatory Chamber President, providing full summary and full details of the case. All of them quickly responded that they would have no jurisdiction to investigate my complaints. The Office of President of Employment Appeal Tribunal wrote that they are unable to provide any assistance because I do not have any current or previous proceedings in Employment Tribunal. And that is simply not true. Judicial Ombudsman responded that they are the correct authority to examine how my original complaint about Employment Judge N. Deol was investigated by Tribunal President Judge Doyle. The Ombudsman, however, may only investigate how my complaint was handled and not the conclusions reached by President Doyle. Similar response I received from Judicial Conduct Investigation Office, which deals with misconduct of judges, such as making a racist remark or falling asleep in court. My allegation of intimidation refer to judicial decisions, and JCIO cannot accept these sort of complaints. The office will not interfere if judges took bribes, fabricated nonsense allegations against me, and ordered me to commit a crime. If the judge committed a criminal offense, I should inform police, and only then the case will be referred back to JCIO. The logic is strange, but that's what it is. So, police is the correct place to report fraud, bribery, and other crimes. Yet, if you call any local office, they will tell you they don't deal with such complex, high-level cases, especially those involving corruption of judges. Crown Prosecution Service will say they are not an investigative body. Action Fraud would not classify your allegations as a crime. A National Crime Agency would also decline to take action. You will be forwarded to Serious Fraud Office, organization which investigates and prosecutes serious or complex fraud, high-level bribery, and corruption. I reported the case to SFO on 13th of August and later sent them a number of updates. In their first response, the office declined to proceed and suggested to contact JCIO and Action Fraud. Later, after carefully reviewing everything, SFO again decided not to launch an investigation because information I shared does not provide adequate grounds to suspect that such offences have taken place. The email was sent on 3rd of March, shortly before High Court judgment, which was delayed by 3 hours after I received an email from SFO. Was it yet another coincidence? Or did British top police agency team up with criminals to intimidate me? It's useful to see a wider picture. Serious Fraud Office reports to Attorney General, who is appointed by and reports to Prime Minister. There is no doubt that SFO informed both of them and took instructions from the top. Another person who contacted Boris Johnson directly was me. I sent him an email on the 2nd of August and the 14th of January, but unfortunately never received any response except for an auto-reply. I was more lucky with Attorney General, whose office did reply to me, but was sorry they were unable to assist. Similar emails I sent to former Prime Minister Lord Chancellor, Chancellor, Secretary of State, and Chancellor of the Exchequer. They all received my emails asking for help, but unfortunately, nobody responded. I always wondered if our Prime Minister will ever stand up and explain to the public why, instead of sandwiches, no one is investigating the worst corruption case in UK history. Does he also participate in the cover-up? The last hope of democracy is free media. For some reason, I thought that only a hint about such a shocking case would draw crowds of reporters. How badly mistaken was I? Having contacted several major newspapers, I was surprised that no one ever responded to me. At some point, I finally met Duncan, a journalist who worked at Wall Street Journal, Bloomberg, and Dow Jones Media Group. He seemed very interested in the story, yet, after traveling to Zurich for a business trip, has changed. Just like lawyer Andrew. Duncan said that I may get into more trouble, and what I really need is a proper support at whistleblower.co.uk. Instead of publishing an article, he inquired if I called the organisation he offered, which I didn't, already expecting more corrupted advisors waiting for me there. Another journalist involved in the case was Bonnie Elslinger, UK courts reporter at Law 360. She published an article portraying me as an offender and crazy opportunist, carefully quoting statements taken out of context and withholding important facts. My claims are groundless, lacking evidence and particularization. A strange conclusion considering that I prepared a 27-page witness statement and an 800-page evidence exhibit. Neither Miss Elslinger mentions that Master Shorman ordered poor whistleblower to pay an additional £30,000 in legal costs to wealthy lawyers without any explanation. I reached a conclusion that if a gigantic, corrupt system tries to destroy a defenseless witness, there may not be anyone in this world who would come with help. People will think that you are either crazy, a liar, or they will get scared and run away, especially if you don't offer any instant payback. Among so much noise around, no one will hear your tiny squeak. If you cry for help, it may be counterproductive, and the louder you shout, the harder they will hit you to keep silent. The only people coming with support would be those who sold their conscience to do the opposite. Passers-by will think that you are guilty of something, and punishment is justified. Even people who are very close may desert you, especially when your offences are confirmed by the courts. If you read news about an official stepping down after disappearance of sandwiches, you may wonder if you live on a different planet and could lose a grip on reality. Some people may mock you as a fool who thinks the world conspired against him and offer mental help. Real offenders will be smiling and claiming to follow highest ethical, professional, and legal standards. I've learned the golden rule the hard way. Don't judge people by what they say and how they look, and focus on their actions instead. Most heinous criminals could be hiding behind a mask of a saint and can easily deceive. Hypocrites may even show acts of heart-touching kindness, but in reality pursue selfish interests. 120,000 Zurich shareholders do not know how management spends their money. Most British taxpayers are not aware they pay a salary of £200,000 to every judge, and billions to different law enforcement organisations. People like conspiracy theories, yet they cannot see what's happening in front of their eyes. Honest citizens believe in democracy, but with criminals in power, the law is worth less than the paper it's written on. As of today, everyone involved in the case is safe in their places, because they know police and regulators will cover them up. Judges, for instance, cannot even be removed from office unless UK Parliament votes for it. At the same time, they can do whatever they want with the next victim. They can put you in prison, or freeze your bank accounts without any explanation. They are not just above the law, they are the law. The ultimate rule of evil. Being the only witness to so many corrupted officials, I may no longer be alive by the time you see this. My name will simply get lost and forgotten somewhere in criminal statistics. I know, however, that I tried to stand up against injustice with what I had, and hope that at least you enjoyed the story. Imagine you discover a powerful dragon hiding in a pile of gold that belongs to the people. What should you do if you suddenly find yourself alone, standing against the monster? Should you run away? Or perhaps sell yourself for cash? The enemy is strong and has impenetrable armor. It's made of people's indifference, self-interest, and fear. Yet, there is a small chance. It's very dangerous, and you may not survive. But don't give up. And don't lose hope. There could be someone who may come with help. Perhaps you could be that person. Freedom is not given for free. You either fall back or make a step forward. What will you choose?